Good morning, everyone. Thanks for joining us or continuing to join us for today's Freece IP webinar. I'm Richard Ellis. I'm Director of Patents within the IP team here at Freece, and I'll be presenting this next session of the webinar on the subject of patents and AI. Just to remind you, this webinar has been recorded, and we'll share the recordings with you once the webinar has finished. As a bit of background to myself, I've been working in the patent profession for almost 20 years, prior to which I was involved in research and development, and I've been heading up our patent function here at Freece for almost 2 years now. So as a former scientific instrumentation engineer in my former life as an R&D project manager, it's interesting to see the expansion of computer implemented inventions, and in particular the increasing prevalence of AI, which is becoming more and more a part of our everyday lives. So in this session, I'll be giving an overview of how artificial intelligence, or AI, continues to impact patents in the UK, and I'll focus on how the current legal landscape is being shaped in this area of law. So although we're getting more and more familiar with AI, I'm going to start with a brief overview of what AI is, and then I'll move on to the main discussion of the latest developments regarding the question of whether AI systems can be recognised as inventors, and how patent protection for inventions developed by or using AI should be pursued or could be pursued. So during the session, I'll touch on what we might expect to see regarding these interactions between patent law and AI in the future. If you've got any questions during the presentation, please drop them in the Q&A box, and hopefully we'll be able to address any questions at the end. So what is artificial intelligence, or AI? Well, a reasonable definition of AI would be that it is technology that enables computers and machines to perform tasks that are typically require some human intelligence, and these tasks include learning, reasoning, which is logical thinking based on data which is received, and decision making, which is forming of outputs based on the received data. AI systems can have elements of perception, language understanding, and problem solving. And on the slide, I've noted sorry, that moved on too quickly. I've noted a few different components that can form part of an AI system. AI systems can be instructed by human users, but generally produce output which is, at least to some degree, independent of that user. So some of the key aspects of AI systems might include machine learning, which is where computers use data to learn and make decisions. Machine learning models are created by teaching or training algorithms to make predictions or decisions based on data. It's essentially teaching a computer to recognize patterns and make predictions based on those patterns. One of the most popular types of machine learning algorithm is called a neural network, who most of you will have heard of neural networks. And neural networks aim to mimic the human brain structure and function. Then we have deep learning, which is a subset of machine learning that uses multi-layered neural networks to analyze complex data. And that can form part of technologies such as image recognition systems and speech recognition systems, which we've probably all come across. AI can also include natural language processing, NLP, which allows computers to understand, interpret, and respond to human language. Examples include virtual assistants and chatbots, which can hold conversations and perform a wide range of tasks, such as generating text and images, such as ChatGPT, which we've probably all used, or variations of. So an AI system might also include computer vision, and this is where different systems may be used in different industries. In computer vision, machines might be able to interpret and make decisions based on visual information from the world, such as recognizing objects in images. An example might be for use in autonomous vehicles to identify speed limit signs and hazards, for example, on the road. And if you've got a reasonably modern car, your car probably does identify those speed limits and hazards as it's driving along the road. Often linked with computer vision, AI systems might also include machine motion, where machines are able to perform motions based on perceptions of the environment and calculations about how movement within the environment can be performed and may indeed affect the environment. Again, as an example, machine motions often used in autonomous vehicles, where radar systems, camera systems on board might be used to determine how vehicles move. So I worked in-house at Jaguar Land Rover for a number of years, and over that time became familiar with many of the autonomous vehicle systems, such as lane keep assist, which keeps the vehicle in specific lanes, or at least warns users, using kind of vibration of steering wheels, etc., that they're drifting from lanes. And other systems such as emergency braking, which hopefully none of you have been in a vehicle when it's happened, but those systems are on many modern vehicles now, all part of these complex AI systems. So AI can be seen in many everyday applications, from those autonomous vehicles I've just mentioned to things such as medical diagnosis and drug development, which is becoming more prevalent. It's used to provide personalized recommendations on social media and streaming services such as BBC iPlayer and Netflix. And it can also be used in fraud detection in banking, which is something that people are very keen on AI systems being involved in, because it's very difficult to often detect fraud in banking scenarios. But the AI systems are being implemented to be able to identify fraud as it happens. And we all obviously continue to see generative AI in action with fake celebrity videos, AI generated books, and AI generated images. So how is AI affecting UK patent law? Well, one area that has been the focus of attention recently is the question of whether AI can be an inventor itself. But to understand this, we need to understand what inventorship generally means in the UK. So in the UK, the right to apply for and obtain patents is governed by Section 7 of the UK Patents Act 1977. And Section 13 of the UK Patents Act sets out the requirements for the identification of the inventors. Section 7 sets out that anyone may apply for a patent, and that patent may be granted to the inventors, or in preference, it may be granted to a person who is entitled by agreement, law, or treaty, for example, an employer, or a successor entitled to either the inventor or that otherwise entitled person. So, Section 7, subsection 3, defines that the inventor of a UK patent application has to be an actual deviser of the invention. Section 13, subsection 2, states that the applicant must identify the person they believe to be the inventor. So in the UK, a patent might be granted primarily to the inventor or to any person entitled by the agreement or rule of law. And the assumption is that unless it's shown to the contrary, the person who makes the application for a patent is entitled to do so. Applicants for patents at the UK Intellectual Property Office, the UK IPO, are required to file a statement of inventorship. And if the applicant is not the inventor, they need to indicate how they derived the right to be granted a patent. So these are the fundamental aspects of UK patent law relating to inventorship in the UK that need to be applied effectively in the question of AI inventorship. So what is the position if the inventor is an AI system? Well, this point has been previously addressed in the Supreme Court decision in the case of Thaler in the Controller General of Patents, which was given back in December 2023, which we discussed in last year's webinar. There have been further developments in that matter, and now I think it's worth looking at what has happened since that previous Supreme Court decision. For those of you who didn't attend last year or aren't up to speed on the matter relating to the Thaler cases, I can just summarize the sequence of events briefly. In 2018, Dr. Stephen Thaler filed some parallel applications at patent offices around the world to effectively try and seek to establish that AI systems can make inventions, and that the owners of such systems can subsequently apply for and secure patents for those inventions. In particular, he filed 2 patent applications with the UK IPO, which named an AI system he'd created, which was a device called DABUS, and it named that AI system as the inventor, as the sole inventor. DABUS stands for Device for the Autonomous Bootstrapping of Unified Sentience, so I'll continue to call it DABUS. The inventions were a food container constructed using fractal geometry, which enabled rapid reheating of food. And the second patent was a flashing beacon for attracting attention in an emergency. And both of these were apparently created solely by DABUS without any human intervention. And the applications by Dr. Thaler only identified DABUS as the inventor. The UK IPO rejected the applications back in December 2019, stating that only a natural person could be named as the inventor under the UK Patents Act. The hearing officer at the UK IPO found that the applications therefore must be taken to have been withdrawn for several reasons. Firstly, it was held that the machine didn't qualify as an inventor within the meaning of the Patents Act. And secondly, it was held that Dr. Thaler was not entitled to apply for patents because for any of the inventions described in the applications, because they were made autonomously by the machine itself, DABUS. So the applications were found to be defective because Dr. Thaler had failed to identify a person or persons who he believed to be the inventor or inventors, and he'd failed to properly indicate how he had derived the right to be granted the patents. So Dr. Thaler appealed the UK IPO's decision to the High Court and then appealed further to the Court of Appeal. Both the High Court and the Court of Appeal upheld the UK IPO's decision, and they emphasised that the term inventor under the UK Patents Act refers to a natural person, and that there is no rule of law that any invention created by a machine would be either the property of the machine itself or the property of the owner of the machine. And so there could be no derivation of rights from DABUS to Dr. Thaler. Dr. Thaler appealed to the Supreme Court, and on the 20th of December 2023, the UK Supreme Court delivered its judgment. They analysed the scope and meaning of the term inventor, both in relation to Section 7 and 13 of the Patents Act, but also in the wider context of the scope of the Patents Act itself. They didn't find anything that would permit the interpretation of the term inventor to encompass anything other than a natural person. So the court ruled that only a natural person could be named as an inventor on a patent application, and therefore upheld the decisions of the lower courts. And they stated that the current legal framework doesn't accommodate AI systems as inventors. The Supreme Court also concluded that since DABUS can't be an inventor, there couldn't be any effective transfer of rights from DABUS to Dr. Thaler, and that Dr. Thaler had no independent right to obtain a patent for those inventions because he wasn't listed as an inventor. So the DABUS applications, the UK DABUS applications, were held to be withdrawn. So what is the latest on this AI inventorship saga? alongside the proceedings on the original UK patent applications, which I've just discussed, an application was filed under the Patent Cooperation Treaty, or PCT. For those of you not so au fait with patents, the PCT is an international agreement which effectively simplifies the process for filing patent protection in multiple countries. It comprises an international phase, and that's followed by potential national phases in any countries, any of the countries who are party to the PCT. So the PCT application for Dr. Thaler claims priority to 2 European applications, and those European applications were filed concurrently with the 2 UK applications for the same inventions, and they were considered, the UK applications were considered by the UK IPO. The European applications are separate, but they formed the basis of the PCT application. That PCT application was then pursued into the UK national phase as another UK patent application. That UK application was then held to be a parent application of the present case. The preliminary examination of that parent application noted that a Form 7, being the form which provides a statement of inventorship in the UK under the UK patent process, they noted that form needed to be filed by the 2nd of October 2021. Dr. Thaler responded on the 1st of October 2021, the day before, stating that the statement of inventorship made in the international phase of the PCT, which again only identified the inventor as Dabus, should be treated as a statement of inventorship under Section 13(2) of the UK Patents Act. So the UK IPO did agree with that statement, but also stated that Dr. Thaler needed to file a Form 7 in order to identify a person who he believed to be the inventor and to indicate how he derived the rights from that person. Dr. Thaler then reiterated his position in a response on the 29th of November 2021, and he requested a hearing. Shortly before the hearing, Dr. Thaler submitted a Form 7 as an auxiliary request, and that Form 7 stated that the applicant identifies no person or persons who he believed to be an inventor. A hearing was held on the 26th of April 2022, and in a decision issued on the 24th of May 2022, the hearing officer decided that the UK IPO should treat the information made in the international phase as if it had been provided on a Form 7, but he didn't preclude the UK IPO from examining whether it met the requirements of Section 13(2). The hearing officer did, however, hold that the information didn't comply with the Act and had in any case been filed out of time, so beyond the time allowed for filing the Form 7, and so the application was deemed withdrawn. Dr. Thaler had filed a divisional application arising out of the parent application on the 10th of May 2022, which was also accompanied by a Form 7 with a statement that the applicant identifies no person or persons who he believes to be an inventor. That application also received objections from the examiner, but on the 22nd of December 2023, which was 2 days after the UK Supreme Court judgment relating to the earlier UK applications, Dr. Thaler filed a further Form 7 in respect of the divisional application, which actually then named Dr. Thaler as the inventor. As part of the submission of that form, an amended first page of the application was provided, which stated that Dabus conceived the invention. Dr. Thaler stated that he built, trained, owned and used Dabus, but that he wasn't an inventor under traditional criteria because Dabus only received training in general knowledge in the field and proceeded to independently conceive of the invention and to identify the invention as being novel and salient itself. So he actually stated that if the training provided to Dabus had been given to a person, that person would meet inventorship criteria as an inventor. And in the present case, DABUS was not created to solve any particular problem, was not trained in any special data relevant to the present invention, and the machine, rather than a person, identified the novelty and salience of the present invention. So essentially, basically stating that beyond some general information, DABUS had conceived of the invention itself without any significant human input. So the examiner objected again, and the matter went to a further hearing before the UKIPO. In the hearing, firstly, it was noted that the Supreme Court decision on the earlier patents had delayed the update of the termination date of the parent application, which was shown on the patent register. The date on the patent register being the 25th of May, 2022. The hearing officer noted that that date was in error and the register should be corrected in order to show the correct termination date of the 17th of June, 2021 instead. Then, since the divisional application was not filed until 10th of May, 2022, which was before the date on the register, but after the actual termination date of the parent application, it couldn't be accorded divisional status. The hearing officer noted that the latest Form 7, which was filed by Dr. Thaler, identified Dr. Thaler as the inventor, but he concluded that there was clear evidence on file that Dr. Thaler had never believed that he was the inventor, such that the UKIPO then wouldn't accept Dr. Thaler's change of mind. And Dr. Thaler then appealed. The appeal was heard in the High Court, and the High Court decision was handed down reasonably recently on the 1st of September 2025. In the first point, the High Court decision affirmed that the patent applications can't use techniques like requesting a hearing in order to delay compliance with the Act and regulations, and in effect play on the administrative load at the UKIPO in order to extend those procedural deadlines. The second point was to address whether the final Form 7 statement of Dr. Thaler met the requirements of Section 13.2 of the Patents Act, given that the earlier forms, all of the earlier forms were clear that Dr. Thaler didn't believe that any natural person was the inventor. While the UKIPO wouldn't normally investigate the correctness of any genuine and plausible statements of inventorship and entitlement, the court held that it doesn't mean to say that the UKIPO is powerless to act when an indication is obviously defective or insufficient. So as such, the High Court held that there was no reason why, in principle, a statement that the applicant believes a natural person or persons to be the inventors cannot be obviously defective. So Dr. Thaler's explanation was that his beliefs as to the facts had not changed, but his understanding of the law had changed after the Supreme Court decision. But the Supreme Court decision merely confirmed that a machine couldn't be an inventor and didn't change the law regarding what qualifies a natural person as an actual deviser of an invention. The High Court responded and said that while it was possible for his beliefs to have changed based on his understanding of the law, his updated Form 7 in 2023 reiterated that he was not the actual deviser of the invention, and all that he did was train the AI, and DABUS was said to have conceived all of the inventions autonomously and independently. Therefore, his later statement of inventorship was deemed to be obviously defective. This decision has been considered by the patent community to be fairly unsurprising, and it doesn't actually particularly advance the AI inventorship debate, but it does direct applicants who use AI to create inventions to ensure that at least one person, one human, is identified as an inventor, and to file the statement that there is a human inventor within the deadline for doing so, and preferably, almost certainly without any prior statements, such as those made by Dr. Thaler, that no person is to be identified as an inventor. So that's the UK position. But but how is AI affecting patent law elsewhere outside of the UK? Well, helpfully, Dr. Thaler filed patent applications in various other countries, naming Dabus as the sole inventor, which has helped test the position of AI inventors in various territories. And I've listed a few on the slide there. So with the exception of South Africa, patent applications in all of the countries in which the Dabus inventions were filed were rejected when Dabus was named as the sole or only inventor. In South Africa, the South African Intellectual Property Office did grant a patent for one of the Dabus inventions. In that case, Dabus was officially named as the inventor, with a note that the invention was autonomously generated by an artificial intelligence. And they had Dr. Thaler as the owner of the patent. The position with regards to patent processing in South Africa is, however, somewhat different to most countries. In South Africa, only checks for basic formal requirements are carried out on patent applications, and there was no substantive examination or even substantive checks on the inventor information that's been supplied by an applicant. So what that means is that the Dabus application in South Africa effectively was granted, even though only Dabus was listed as an inventor, purely because those aspects aren't investigated during the patent process in South Africa. Some commentators have suggested that even this South African Dabus patent that was granted wouldn't be legally sound, on the basis that whilst the South African Patents Act doesn't define the term inventor, it would appear that the legislature there intended the term inventor to be limited to a human being. That point, to my knowledge, is yet to be tested by any objection from a third party to the South African Dabus patent. So South Africa remains a bit of an outlier. In Germany, one of the Dabus inventions was allowed, but only when the list of inventors was changed to explicitly state Dr. Thaler as an inventor, with the addition of a statement that Dr. Thaler prompted the artificial intelligence system Dabus to generate the invention. It's also worth noting that the Federal Court of Justice in Germany has decided that AI can't be an inventor alone, so as a sole inventor. So that position does appear similar to that in the UK, where it may be acceptable to identify AI as an inventor, or at least as a contributing factor to an invention, as long as there is a specific human listed as an inventor. Germany, however, appears to have allowed the about face by Dr. Thaler in adding himself as an inventor late on in the process, after initially only stating that Dabus was the sole inventor, and that position is obviously somewhat different to the position that was taken in the UK, where they didn't accept the addition of Dr. Thaler later on in the process. Elsewhere in Europe, the Board of Appeal of the European Patent Office in case J8 of 20, again relating to one of the Dabus patents, noted that an inventor must be a natural person with legal capacity, or in other words, a human being. They referred to the Oxford Dictionary definition of the inventor as being a person who invented a particular process or device, or a person who invents things as an occupation. And they stated that the EPC, the European Patent Convention, doesn't use the term inventor in any special way, which would depart from that ordinary dictionary meaning. In Japan, Japanese patent law defines inventions to mean products of human activity. So that precludes the possibility that the sole inventor on a patent could be AI. In May 2024, Tokyo District Court dismissed an appeal against the Japanese Patent Office's rejection of one of the Dabus patent applications, where the rejection was based on the sole inventor being AI. However, the presiding judge at the time acknowledged that There were issues with the position, and that it was something that the Japanese lawmakers may need to address, given that the current patent laws in Japan didn't anticipate and had never anticipated these new types of inventors, the AI inventors. So it's clear that at least some territories, such as Japan, are starting to consider what changes may need to be made to laws to accommodate inventions produced solely by AI. In the US, the USPTO, the US Patent and Trademark Office, determined that the patent applications lacked a valid inventor, and they issued notices requesting identification of valid inventors. Dr. Thaler petitioned the USPTO director in order to try and annul the notices. The USPTO denied that petition. Dr. Thaler then sued the USPTO in the US District Court. The District Court granted the USPTO's motion for summary judgment, and they concluded that the applications lacked an inventor because under US law, an inventor must be an individual, and the plain meaning of individual was held to be a natural person. Dr. Thaler appealed to the Federal Circuit in the US. The Federal Circuit noted that the United States Code relating to inventions for patents, which is 35 USC 100F, defines the inventor as an individual or individuals who are natural persons, therefore requiring the inventor to actually be a human. While the term individual isn't defined by US patent law, the court noted that the ordinary meaning of the term refers to a human being. And then the US Supreme Court finally declined to hear Dr. Thaler's final appeal, which effectively ended his legal challenge in the US. Taking probably a little bit of a lead on other countries, the USPTO have subsequently issued inventor guidance for AI-assisted inventions, which addresses the question of whether inventions made by human beings with the assistance of AI are eligible for patent protection. And the USPTO have concluded that since the law requires the inventor to be an individual who invented the subject matter of an invention, and an individual is defined as a natural person, that any joint inventors must also be a natural person, which thereby precludes the naming of AI as an inventor at all in the US. Obviously, the UK have also made some commentary on their system and amended the guidance for inventors relating to AI inventors, but I won't go into that too much today. While AI systems can't be listed as inventors on patent applications or patents in the US, the use of AI systems by a natural person doesn't preclude that natural person qualifies as an inventor if that natural person significantly contributed to the claimed invention. So in the US, patent applications and patents for AI assisted inventions must name a natural person who significantly contributed to the invention as the inventor, and should not name an AI system. So there's a little bit more clarity in the US, and at least a little bit more guidance than in many other territories. But it's clear that the AI system definitely in the US shouldn't be named as an inventor. There's been further refusals to the DABUS patents in various other patent offices: Canada, China, Israel, New Zealand, South Korea, Switzerland, amongst quite a few others. In Canada, the Canadian Patent Office noted that an inventor can't be a machine because machines don't have rights under Canadian law, and so it's not possible for machines to transfer those rights to a human, which is similar to the position in the UK. In South Korea, the Seoul High Court noted that Article 33(1) of the Korean Patent Act specifically states that patent rights can only be granted to a person who makes an invention or a successor thereof. So again, similar to the position in the UK. Some of these cases, however, are still in the appeals process, so haven't necessarily reached a final conclusion. Finally, what are the implications of the decisions? Well, in general, it appears that until legislation is enacted to address the patentability of wholly AI-generated inventions, some element of human involvement would remain a requirement across the world for patent protection. The Supreme Court's decision in the UK obviously has a significant impact and significant implications for the future of AI and patent law in the UK. It's highlighted the need for potential legislative changes to address the evolving role of an AI in innovation. Indeed, in the decision itself, it was noted that there is a question of whether the definition of the term inventor itself needs to be expanded to include machines powered by AI. And that question's one of that effectively raises policy issues about the purpose of the patent system, because the purpose of the patent system is to foster innovation, and by preventing these protection for AI generated inventions, it can be seen to be more stifling innovation than fostering it. So in the meantime, given the comments in the various courts, including those outside of the UK, we should always identify a natural person as an inventor, even if the invention was conceived by AI or using AI. And that natural person could be, for example, the person providing instructions to the AI system, or more likely in the Dabus case would be the developer of the AI system. The UK IPO don't examine, and in fact, I believe can't examine whether the named inventor is an actual deviser of the invention, or even if they exist at all. So at present, this is the safest way to ensure AI conceived inventions can be protected. It's obviously advisable not to name AI as an inventor at all, as it's clear that a number of territories will reject applications on that basis, or at least it will complicate the patent application process in those territories, such as what happened in Germany, for example. But if, for example, a UK application is filed which does name an AI as an inventor, obviously with a natural person also identified as an inventor, and then a US application is subsequently filed which claims priority to the earlier UK application, then the presence of AI as an inventor on the US application would have potentially fatal consequences for the US application. So it's likely over the next few years, the UK government, other international bodies will continue discussions on how to adapt patent laws to keep pace with technological advancements. And I think we can all look forward to more AI-related cases in the future. So that concludes the main body of the presentation. I think we're still in time. If you've got any questions, you can add those to the Q&A. The box might have disappeared. So I can't see the chat box, but one of my fellow panelists has asked if I can say something about what will happen in the emotional perception case, and whether the UK should align assessment of computer implemented inventions with the EPO's approach. I think that's quite a complex. It's a little bit outside of what we're talking about here today. But I think in the emotional perception case, which was the subject of previous webinar, I think generally the UK has come to a little bit of a conclusion that we effectively follow the same processing for AI based inventions, not AI generated inventions, but inventions involving AI to be analysed and examined in the same way as the computer implemented inventions in the UK. There's a lot of talk at the moment about how the processing of inventions involving AI effectively differs from how such inventions are examined at the EPO. And I think a lot of the talk is to try to change the way that UK applications are amended to be more of a European examination process. I think that's going to take some time to try and filter through, but certainly there's a lot of talk about the process, and we really haven't got time to go into it. But the process that's run in the UK is a different examination process than is run in the EPO, and I think, although those processes are intended to reach the same conclusion on computer inventions and AI inventions, they often do have some disparity. But I think over time we'll probably converge a little bit, but it really needs perhaps more cases to push that processing towards the European style of patent examination. I don't know if there's any more questions because I can't see the chat box, probably without stopping my share. So I don't know if there is anything there, Martin, but I think we've reached pretty much the end of the time.